Good afternoon, everyone. Great to be here. I do bring you greetings from our President and CEO, Tom Wright, and from our Registrar, Joe Riche, who's actually attending the OREB PAC event. Before I get on to the main subject matter of my talk today, which is going to be about the complaints and discipline process, a couple of items of late-breaking news that might be of interest to you. First, I'm aware that in the Ottawa area there's been a long simmering issue with respect to attendance at home inspections based on some comments I made at RECO's AGM back in April. Probably not my most stellar moment of communications, but it is what it is. However, I can tell you that RECO has just issued its latest issue of For the Record. Most of you should have received an email notifying you about this. And right there, the cover edition, the cover issue is, do I have to be present for a home inspection? And when you look inside, on page 3, you'll see a brief article that speaks to the issue. I'll just read you a couple of key paragraphs just to set the key issue straight, and certainly you can look at the details online. It says here that registrants have an obligation to protect a client's best interests under the Code of Ethics. As such, anytime a non-registrant requires access to the property in the course of completing a trade, RECO recommends that you obtain clear written confirmation from your client about whether you are to be present. This applies whether you're representing the buyer or the seller. Given your obligation under the Code of Ethics to promote and protect the best interests of your client, it's a good idea to discuss and document whether you will be present during home inspections and the like. If something does go wrong, a written record confirming the arrangement demonstrates your diligence in seeking direction from your client, ultimately serves to protect both you and your client. And in terms of how this might be documented, an acknowledged email would suffice. So that's sort of the long and short in terms of clarifying that particular issue. The other late-breaking item is just yesterday, the Ontario government had Bill 55 go through third reading. And that's a bit of an omnibus piece of legislation. It makes a few different changes, but it does make 2 changes to the Real Estate and Business Brokers Act. The first change relates to document retention that is ultimately aimed at preventing phantom offers, and establishes certain requirements on the part of brokerages in terms of retaining certain documents. Those changes, while they've passed third reading and they'll get royal assent, they won't actually be proclaimed until a future date. Details still to be worked out, but I think we need to get some regulations in place to go along with those changes. But the one change that will take place as soon as royal assent is received is that will allow brokerages to charge a combination of flat fee plus percentage commission in terms of collecting fees from clients. So at the moment you're restricted to one or the other. So you can charge a flat fee or you can charge a percentage of price, but you can't do both. With these new changes, as soon as that receives royal assent, brokerage will be able to do both and say, for example, $1,500 flat fee plus 1 or 2% commission, if that's what you want to do. So it gives you a lot more flexibility in terms of your pricing for your clients. So with that as the late-breaking news, I'll move now into the main aspect of what I'm going to talk about today, and that's our complaints and discipline process. We've had a lot of interest around the province, frankly, in terms of this process. And it's one of those things that, as you'll see based on some stats, most people don't know about because you don't get involved in. And I often see this as an opportunity to learn this the easy way by me telling you about it, rather than having to learn it the hard way when you find yourself being faced with a complaint and potentially going through it. So it's much better to deal with me in these circumstances than the alternative. As you know, of course, RECO is the regulator. It's our job. We're a consumer protection organization. We administer the Real Estate and Business Brokers Act. Our objective is to ensure that there's a fair, safe, and informed marketplace and that trading takes place in a fair and ethical manner. As a regulatory body, any regulatory body, be it ourselves, the ones for engineers, the one for doctors and lawyers, all have a complaints and discipline process. And those are in place because as consumer protection organizations, the protection of the public is one of their fundamental aims. But the complaints and discipline process also serves a couple of other objectives. It does provide a level of deterrence against unethical conduct. When folks such as yourself become aware of what the potential consequences are with respect to unprofessional conduct or misconduct issues, it does serve as a deterrent from repeating that conduct that was done by others. But more importantly, from our respect, the complaints and discipline process provides an opportunity for rehabilitation. Certainly not every complaint and not every instance of unethical conduct warrants somebody losing their registration. That's certainly not the attitude we take. But it's possible that the misconduct or the unprofessional conduct takes place because of gaps in someone's knowledge or awareness of certain circumstances. And we can use the complaints and discipline process to rehabilitate folks, to fill in those gaps so they can go on and continue to trade in the future. It's certainly not about any aspect of just pure punishment and retribution on the part of RECO. And in looking at the complaints process, of course, one of the best things to do, again, in learning it this way, is to learn how to avoid getting involved in the complaints process. So we're going to briefly talk about the 4 main areas that are sources for complaints that RECO receives. So if you manage to stay clean from most of these, there's a very, very minimal chance you'll have to deal with me in my more formal capacity. First main issue that's the basis for complaints is disclosure. Under the Real Estate and Business Brokers Act, registrants have a myriad of disclosure obligations. You've got disclosure obligations when you first sign up a client. You've got disclosure obligations relating to the material facts regarding a property. It doesn't matter whether you're representing the buyer or the seller. You've got disclosure obligations if you're representing a seller and there's a competing offer situation. You've got disclosure obligations if your brokerage is in multiple representation. You've got disclosure obligations if there's issues of conflict of interest. So the legislation is just filled with all of these disclosure obligations on you, and they're there to protect consumers and to protect the public. But it is issues of non-disclosure or incomplete disclosure relating to those items that become sort of the number one on the hit parade for us with respect to source of complaints. So obviously we recommend fully complying with one's disclosure obligations. Number 2 on the list are issues of misrepresentation. And that can be sometimes overt and intentional, sometimes it's inadvertent, but it's just the idea of making a statement that is not entirely true. And as for example, making a statement on a listing that there are hardwood floors underneath the carpet. Maybe there are, maybe there aren't. What's your basis for making that statement? And I can tell you that a lot of the misrepresentation issues we get, where there are errors in listings or errors in advertising for a particular property, the number one excuse we receive from registrants is, oh, that's what the seller told me. And frankly, I'll tell you right now, as an excuse, that doesn't carry a lot of traction with RECO. For a lot of things which are frankly easily verifiable, including the status of what's underneath a piece of carpeting, or whether the property taxes for a property are what the seller said they were, saying that, well, that's just what the seller told me and I put down what they told me, isn't going to carry a lot of water. So there's issues of misrepresentation that, like I said, are number 2 on our most frequent list. Next is a category of things that refer to relating to fairness, honesty, and integrity. There is a specific provision in the Code of Ethics that says registrants shall treat every other person in the course of a trade with fairness, honesty, and integrity. Okay, so it's not just a matter of treating your client that way. You have an obligation to treat the representative on the other side of the trade, their clients, the home inspector gets brought in, mortgage brokers, any other person that you're dealing with in the course of a trade, you've got an obligation to treat them with fairness, honesty, and integrity. Now, from our perspective, in terms of what those words mean, fairness, frankly, is all about a level playing field and not showing bias to one person versus another. So if you're representing a seller and you've got, let's say, a half a dozen other registrants who represent buyers who are interested, you treat them all equally. Everybody gets the same information, everyone gets the same opportunity. You can't think to yourself, well, I don't like this person because I think they screwed me over on a previous deal. I'm not going to tell them something that might actually seal the deal for them. Because that's not really acting in the best interest. A, it's not fair, but it's also not in the best interest of the client trying to sell the property. Issues of honesty, I'm really hoping I don't need to explain what honesty is. I think that's a fairly straightforward term for most adults, thank you. And the issue of integrity, I like to paraphrase this way. It's say what you mean and mean what you say. All right, so be very clear in your communications and be succinct. Don't use weasel words and waffly terms that you can hopefully then twist around later on. Be very straightforward in your communications. And then when you do tell someone something and that you're going to do something, actually do it. Basically do what you said you were going to do. That's a really key important in terms of integrity issues. And the last issue then on our top 4 is issues generally of professionalism. Now there is a provision again under the Code of Ethics that speaks to not doing anything that would be considered disgraceful, dishonorable, unprofessional, or unbecoming a registrant. But there's a difference between being professional and being not unprofessional. It doesn't quite sound like you think there's a difference, but the fact is there is. As the regulator, our objective and our ability is to ultimately enforce a certain, call it a minimum standard of practice. If you stay above that minimum standard, you're not going to run afoul of RECO and you shouldn't be finding yourself in this particular process. But as soon as you dip below that minimum, you've clearly breached some aspect of the regulations, and then you're going to be hearing from us. There's a whole spectrum, of course, in terms of professionalism, and from our perspective, being a true professional is more than just following the rules. This idea of putting your clients first. Yes, there's the requirement to promote and protect their best interests, but putting their own interests ahead of your own, in the course, is what a professional does. There's issues of taking accountability. The idea that when you do make a mistake, you own up to it, you admit it, and you take steps to correct it. Don't try and point fingers at other people, don't try and sweep things under the rug, don't wait for a complaint to be filed before you decide to take some sort of corrective action. Hold yourself to high ideals. Like I said, if you're coming along and as an objective, all you're trying to do is stay out of RECO's radar and you're operating right at that minimum level, someday you're going to have a bad day. And on that bad day, you're going to fall below that level and run afoul of RECO's legislation. However, if you keep yourself at a higher standard, you can still have a bad day and be well above the minimum. All right. So in terms of professionals, tend to put themselves for that higher ideals. And then the last item here is the idea of engaging in constant learning. Yes, RECO sets out certain minimum continuing education requirements that you need from a regulatory perspective, but true professionals recognize that there are other professional development and business development things that they need to do that aren't mandatory or required by RECO in order to maintain a good level of professionalism. So, notwithstanding now having understood the main things you can avoid to having a complaint filed against you, what happens if, in the unfortunate circumstances, one does get filed against you? So I might just talk a little bit about that. The first issue, of course, is don't panic. The fact that you've received a letter from RECO, typically either signed by me or on my behalf, saying that we've received this complaint, doesn't mean that RECO has made any findings. We haven't drawn any conclusions. All it says is we've received a complaint from someone, be it a consumer or potentially another registrant. We are obligated under the legislation to pursue certain complaints if things are within our jurisdiction. We're advising you of the complaint and we're going to be seeking information from you. Like I said, we don't necessarily believe what's being said. We fully understand that consumers and people who make complaints lie. Sometimes they just have different perspectives on things. So again, we've drawn no conclusions on the basis of the fact that the complaint itself has arrived. The general process is we will receive complaints from consumers or registrants, and the breakdown at the moment is about 35% of our complaints come from other registrants and 65% come from consumers. And we're looking at about 12 to 1,500 complaints a year on average, sort of over the past few years. So we'll receive that complaint. We will notify the registrant who is involved in the circumstances and request a response from them. We want their side of the story. We want to be able to make a decision understanding both sides. We'll also conduct any further inquiries or investigations so that indeed we do get the complete picture. It's entirely possible that the complainant has one version of events, the registrant who's being complained about has another version of events. There may be some independent witnesses who have some information, another registrant that was involved but is not being complained about, some other consumer who can try and tell us, well, what was said and what was done and so on to give us that complete picture. Because we do only want to make a decision on a matter based on a complete understanding of the circumstances. And once we have that, we'll decide what action needs to be taken. If you do happen to become the subject of a complaint, one of the most important things to do is, obviously if you're not a broker of record already, is to notify your broker of record. Because under the legislation, when we have notified you that you're being complained about, we've already notified your broker of record that you're being complained about. And I always think it's a much easier row to hoe to say, call them up and say, okay, listen, I know we've received this complaint, let's sit down and talk about how we're going to respond, rather than ignoring it, maybe hoping it'll go away, and then you get a call from your broker of record saying, hey, what the hell is going on with this complaint, and I think we need to do something about it. So by all means, discuss the complaint and the circumstances with your broker of record. And the other decision you'll need to make is, do you want to retain any sort of legal representation at that time? It's not something that RECO either recommends or recommends against. This is a completely independent decision on the part of the person facing the complaint. But what's important to recognize is that if you do choose to retain legal counsel, it doesn't change anything with respect to the way RECO is going to process the matter. So the fact that you decided to respond through a lawyer doesn't make us think, aha, this person has something to hide, or they're doing this because they don't want to have full disclosure and full interaction and so on. Absolutely not. It changes absolutely nothing with respect to how we will process a complaint. So as I mentioned with respect to the 4 steps, then once we do complete our investigation, we get the response back from the registrant. I will review the file and make a determination about what the next course of action is. And under the legislation, the actions available to the registrar sort of fall into 2 groups. There are administrative actions that don't require any sort of a more formal process, and then there are what I call judicial actions that do require a more formal process and some sort of hearing. Under the category of administrative actions, these are things which I, as the Deputy Registrar, can decide to do, again, without any further process, shall we say. First and foremost, take no action whatsoever, all right? Dismiss the complaint, basically, because the inquiries and the evidence either don't substantiate the allegations that have been made, i.e. the complaint had no merit, or otherwise are inconclusive. We get a number of complaints in which is a he said, she said, and that's all it is. It was a conversation. Oh, the real estate professional promised me this was going to happen, and it never did. And the real estate professional responding to the complaint says, no, I never promised that. I talked about this other thing, and no one was around, so there's no way to confirm the truth of what actually happened. And in those circumstances, the tie goes to the registrant. And that's just the only way to be fair about all of this. So a number of complaints, again, I'll get into stats in a moment, are dismissed simply with no action because we could not substantiate what's being alleged. Second, this one's not done very often, but we can request, get a voluntary consent to having conditions placed on the registration of a real estate professional. Third, we can actually get involved to attempt to mediate or resolve the complaint. The power to do this has been in the legislation pretty much since the beginning, but it was only earlier this year, back in about January, that we did initiate a mediation process for complaints of a certain type. And we've had a good bit of success. There's been over a dozen complaints now that we've gotten involved, mediated between the registrant and the consumer, and ultimately made everybody happy, and the complaint goes away, and there's nothing further that needs to be done. Continuing sort of up the scale, shall we say, perhaps of more seriousness, the registrar can issue a written warning. And the written warning is going to simply say, if the conduct that led to this complaint continues, then more serious action may be taken. So it's not a question of saying, yes, you did something wrong and you breached the legislation, because the registrar, without a hearing, can't make any finding that way. But there are concerns with respect to the conduct that took place, and we're just sort of putting you on notice. You might want to change how you deal with these sort of issues, lest you're going to find another complaint in the future. And then at the more extreme end of the spectrum, the legislation gives the registrar the power to require a registrant to take an educational course at their own expense, obviously. So that would be, again, if we think, based on the circumstances, there's a gap in someone's knowledge, and we think there's a course out there that can help fill in that gap, then we can require that registrant to take that course. If the nature of the complaint and the findings from the investigation are a bit more serious, and we believe that more serious sort of consequences are required, then we're moving into what I call judicial actions, where there is some sort of a hearing necessary. And the first and foremost would be keeping things internal to RECO, is to refer the matter to our discipline committee for a hearing. And I'll talk a little bit about that process in a few moments. Other possibilities under the legislation, the registrar has the power, again, where there's a public interest basis for doing so, to issue an immediate suspension of someone's registration. Now that also kicks in other requirements with respect to how soon you get a hearing if you've been immediately suspended, but again, that's a secondary issue. Outside of an immediate suspension, again, where the conduct is serious enough, the registrar can propose to suspend or revoke the registration of an individual. And if that proposal is challenged, that then goes to a hearing to an outside organization called the License Appeal Tribunal. It's an independent body. They do adjudications of licensing issues for a number of different organizations, including ours. But if there's a challenge to that proposal, that's where it's taken. And then lastly, if the nature of the breach doesn't relate solely to the Code of Ethics, if it's some other aspect of the legislation, then it's possible for RECO to prosecute that offense, the breach of some other legislation, or other regulation, in through the provincial offences courts. That's so in the public court, the same way you'd go to for a Highway Traffic Act type violation. You could end up going to the external courts and be charged with a breach of some aspect of the Real Estate Business Brokers Act. But what I want to focus on now is issues regarding the discipline committee. Having, again, this internal complaints and discipline process is important, and the penalties that are issued by the discipline committee, and I'll talk about what they are just in a moment, they serve a couple of different purposes. They help preserve public's confidence in RECO as a regulator. And it's really important because if the public doesn't have confidence in RECO as a regulator, we can't do our job because no one's going to bring things to us. And if they haven't got confidence in us, they're not going to have confidence in the real estate industry in general. Okay, so it's confidence in us helps reflect confidence in yourselves. And then, of course, it does serve as that deterrent element. We don't want unethical conduct to be, and the discipline arising from unethical conduct, to be just a cost of doing business. So for the fines that are issued by the discipline committee at the end of a hearing, they have to be meaningful relative to the conduct that took place. So if, for example, a registrant did some sort of unethical conduct and they were profiting to the tune of, let's say, $8,000 by it, and if at the end of a discipline hearing, the discipline committee awards a $2,000 fine, might not be argued as much of a disincentive, frankly, to repeat the conduct. However, if it comes down the pipe with a $15,000 fine, that individual is going to think long and hard again before repeating that conduct. Of course, with discipline decisions being out there in the public, all you folks get to find out about what's going on and what kind of consequences there are from certain types of misconduct. You'll be have a disincentive from repeating a similar type of conduct as well. Now, the good news is, one of the reasons that folks generally don't know about the complaints and discipline process is because very few of you actually get involved in it. As I said, we have 65,000 registrants, and yet only deal with about 1,200 to 1,500 complaints a year. So if you want to look at the math, it's roughly 1 in 46 registrants is going to be at the bad end of a complaint in the course of any year. I can tell you, I know the stats for a number of the other professions, both doctors and lawyers in Ontario. The number is 1 in 10. Okay? 1 in 10 doctors, 1 in 10 lawyers will receive a complaint in any given year. All right, so they have, typically, I forget which organization is which. One has about 25,000 members, the other has 30,000 members, so they're dealing with 2,500 to 3,000 complaints a year. It just boggles my mind. If we had numbers like this, where I'd be dealing with 6,500 complaints a year, I need like 3 times the staff that I have now. So the good news is we don't get a lot of complaints. And even for the ones that we do, when you look at the pie chart, I'm not quite sure how well that can be seen from the back, but fully 50% of the complaints we receive get closed with no action. All right? We cannot substantiate the allegations and/or the allegations appear to have no merit. Essentially, everything that's in our investigation file, whether we plan to rely on it or not, the registrant, who is technically now a defendant, is fully entitled to disclosure of all that information, and that's what we provide. We go from there into a pre-hearing. And the idea behind a pre-hearing is to have a little bit of a less formal way of hopefully addressing the matter and getting it resolved. Pre-hearings are overseen by a single member of the discipline committee. It's a less formalized process. There's no official calling of evidence. It's all done on a without prejudice basis. But its intent is to sort of focus the issues and hopefully resolve. And by way of resolving, either have the registrant admit in terms of what took place and admit there were breaches of the Code of Ethics, or, and sometimes happens, is the registrar will bring additional information that they didn't supply with their first response to the complaint and demonstrate that indeed there was no breach, in which case RECO is quite happy to withdraw the allegations if that's the case. So that's certainly the intent, again, is to just on an informal basis, let's all just talk about what really happened. Nothing anyone says is going to be held against them if we go to a hearing, but let's try and get it resolved in front of one member of the discipline committee who can provide that sort of independent perspective. Now, the good news is that 90% of the matters that go on to a discipline hearing, and right now that's only about 30 to 40 sort of those matters per year that are referred to a hearing, 90% of those get resolved, either through an agreed statement of facts and agreement on penalty, or with respect to RECO deciding to withdraw its allegations because we now realize a different perspective on our case. So now in terms of where we stand from that initial 1,200 to 1,500, we're now down to maybe 3 or 4 cases a year that will actually go on to a contested hearing. And if that's required, a contested hearing is very much like a court case, very much like a court trial, very much what you see on television, frankly. We have 3 members of our discipline committee who sit as a panel as the judges. RECO acts as the prosecutor, represented by one of our legal counsel. The registrant is the defendant. Most often will also have legal counsel. Sometimes they don't. That causes more grief than anything, frankly, is an unrepresented defendant. And the process is, because the onus of proof is, and the burden of proof is on RECO, we'll present our case first. We'll call witnesses who have to be sworn to provide the testimony. Everything is recorded. Exhibits are marked. Documents are marked as exhibits when they're filed. The witnesses we call get cross-examined by the defense. When our case is in, the defense puts in their case. We get to cross-examine their witnesses. Again, the standard process you might see on almost a Perry Mason sort of situation. And then at the end, our submissions from both sides as to what should the panel think about what actually happened. But as I note, at the start of that hearing, the registrant is presumed innocent. That is standard aspect of law in Canada. You are presumed innocent until you're proven guilty, and it's RECO's job, it's our burden to prove that the breach that we allege took place actually took place. So, as I mentioned, the case goes through in terms of our case going first, the cross-examination of witnesses. The lawyers present their final arguments. When the final arguments are done, the panel members then go off and deliberate, and they'll reconsider the evidence, and they have a decision to make. So they have to decide, did this breach take place the way that RECO says it did? And they do that to a standard that's called the balance of probability. So it's not RECO's job to prove beyond a reasonable doubt that the breach of the Code of Ethics took place. It's our job to prove to a balance of probabilities, which is basically a 50% plus 1. The idea in terms of the heads of the discipline committee, all they have to satisfy them is it more likely than not that things happen the way that RECO said it did versus perhaps the way that the defense has presented it, okay? So it's not beyond a reasonable doubt. And because there are 3 panel members, the vote does not have to be unanimous, it's simply a majority. So sort of boil it down to its lowest essence, RECO's job at a discipline hearing is to convince 2 panel members out of 3 on a balance of probabilities basis that it's more likely than not that the breach took place the way that we said. After they've done their deliberation, they will ultimately issue their verdict, their decision. This is done simply in writing. The members don't just sort of go off for an hour or so and discuss this and then come back. They will issue a written decision with the finding, with all the rationale behind the reasons for that finding, and they will determine what the penalties are. And the penalties that are available to a discipline committee is actually, there's only 2 things they have in their toolbox, so to speak. They can issue fines. The fines can be up to $25,000. And they can also require someone to take an educational course. So the same power that the registrar has in an administrative section or sense, the discipline committee can do at the end of a discipline hearing. But those are the only 2 things they can do. The discipline committee can't revoke or suspend or put conditions on a license. Now, after the decision is issued, if the registrant has been found not guilty, it's possible for them to apply to receive some of their costs. There's very specific rules under the discipline committee in terms of when those costs can be awarded, but it's not unprecedented for it to happen. If the registrant has been found guilty, then they have 30 days to initiate an appeal. And the appeal still stays within RECO. We have an appeals committee that is set up specifically to deal with appeals from the discipline committee. And all of this is generally done in writing. An appeal is not just a rehash of the actual hearing. Appeals have to be based on the opinion on the part of the party making the appeal that the original discipline committee made some sort of error in fact or made some sort of error in law. And the appeal is really all about those particular errors and how they would have influenced the decision. So It's also possible, of course, if RECO doesn't like the outcome of the hearing, that we can appeal the decision. And that's happened once or twice that I can think of in the last certainly 3 or 4 years. It's not that frequent, but it's possible for that to happen as well. It may be that we think in the interest of consumer protection and the interest of justice that there was some error made on the part of the discipline committee in their consideration of the matter. And either, even if they found someone guilty, sometimes we might just appeal on the issue of penalty because we're concerned about the precedent that's going to be set, and we're concerned about that whole cost of doing business issues to say, listen, if this kind of conduct is seen to get such a light penalty, that's going to cause issues with respect to public perception and so on. So again, it doesn't happen very often, but it's still possible. And like I said, this is all done in writing, and an appeal, then the decision would also come out in writing. So this is everything I wanted to cover off in terms of the complaints and discipline process. Before I wrap things up and take some questions, though, I would like to speak briefly about the new continuing education program that was launched by RECO back on August 1st. Some folks are curious now that we're into what we call our transitional period. If you have a registration renewal coming up anywhere between now and July 31st of 2015, you've got options in terms of how you meet RECO's continuing education requirements. So I just want to cover off what those options are, and there's 3 of them. First is that you can go online and take the RECO's update course that's delivered online by RECO. Go in through my web to register for that, and take 2 elective courses. Currently there are 4 that are available. There should be 6 by the end of the year, but all you need are 2. And that's all you need to do to meet the continuing education requirements. It's a $44 cost, good for that 2-year period. And then you take the update course, 2 electives, and you're done. This would be attractive to someone who, for example, hasn't really done anything yet with respect to their continuing ed. So if you haven't gotten credits that you're carrying forward from the old system, here's a chance to just go in fresh, because after July of 2015, this is going to be the only way that you're going to be able to meet the requirements anyway. Option number 2, if you're somebody who happened to have taken the RECO update course with OREB, so the in-person course prior to July 31st, because obviously they stopped offering it at that time, then you can still use that. And you can still take a total of 18 other credits by third-party providers, just the way the old system worked. All right, so you can still do everything from the old system, provided that, of course, you did take the update course prior to July 31st. So again, this would apply only to those who have taken the course then, and perhaps you already have 15 out of the 18 other credits that you need. This is going to be the option I think that would be most appealing. And then last, the other option is a blend, which is to take the update course online. You still pay the $44 as you register for the online education program. Take the update course online, but you can still do all of your elective material through third-party providers. So again, this would be useful for someone who wasn't able to take the OREB version of the RECO update course prior to July 31st. But you've still got 15 or so other credits that you've just as soon make use of. So this way, all you have to do is take the update course online, take the balance of the credits that you need for the other 18, and you've got the circumstances taken care of. The one combination of permutation that you're not going to see here, because it's frankly it's just not available to you, is that if you took the update course through OREB in person, you can't go online and just do the electives. The system's just not set up that way. If you're going to be going online, the very minimum you're going to have to do is the update course, and then it's your choice if you do that plus 2 electives or not. So those are the 3 options that are available to you. And at this point, I'm happy to take questions on any particular issue.